Generally speaking, usually the properties are divided into two parts. One is known as landed property and other is known as non-landed property. It includes houses, buildings, commercial sites, shops, etc. So when the two co-owners want to get the property partitioned, first of all, it is to be determined whether the property is land or not. If the property is land, then the procedure lies in the West Pakistan Land Revenue Act 1967. So the partition of the land is regulated by Land Revenue Act. The party which intend to get the property partitioned, he is first to determine whether he wants partition of the land or he wants partition of the property other than the land. If the property is other than the land, he shall have to resort to the civil court. But if the property is land, then the procedure is provided in the Land Revenue Act 1967. The partition of the land is regulated by Chapter 11 of the Land Revenue Act. An application is moved under Section 135. Any joint owner of any land may apply to a revenue officer for partition of the share in the land. If at the date of the application the share is recorded under Chapter 6 as belonging to him, or his right to the share has been established by a decree which is still subsisting at the date, or a written acknowledgement of that right has been executed by all persons interested in the admission or denial thereof. So, the nutshell of this section is that a co-owner may apply to the revenue officer. So, the word revenue officer is used and not the revenue court. And the partition is through an application, not through a suit. So, the partition under Section 135 of the land is on the basis of an application by a co-owner. Any joint owner of land would be entitled for partition of his share in joint property. PLD 1992, Peshawar, page 37, where question of title had arisen, then either the revenue officer could himself take cognizance of the matter or refer the question to civil court. Persons who had purchased land after order of partition had been effected would not be competent to raise the question of title, and jurisdiction of civil court could not be invoked. So the question involved related to mode of partition, and as such civil court had no jurisdiction. So in the nutshell is that when there is no question of any title and the parties are co-owners, then the civil court shall have got no jurisdiction to adjudicate upon the matter. Now, there is a bar on jurisdiction of civil court in terms of Section 172 of the Land Revenue Act 1967. It could not be presumed that all revenue authorities and courts had not adverted to the facts of case and had not granted proper opportunity of hearing to petitioner. Hence, plea of petitioner that he was not granted proper opportunity of hearing could not be accepted. Revenue forum and not the civil court had to take care of value of the land. So in this situation, again the jurisdiction of the civil court is barred under section 172. So the basic principle is that partition of the property, which is land, is regulated by the revenue officer under the provisions of Land Revenue Act 1967. Another question has been dealt with. 2000 MLD, page 796. It reads as follows: Revenue officer under the provisions of West Pakistan Land Revenue Act 1967 can assume jurisdiction as court whenever the question of title is disputed between the parties. Such powers are totally absent of the West Pakistan Redemption of Restitution Act. So the jurisdiction of the Revenue Court only relates to the partition of joint land. Entries in column of ownership and cultivation. What is the legal status thereof? Vendee of specific khasra number of joint khata, rights of extent has been stated. You may go through 2011 YLR 1397. Partition of agricultural land is within the jurisdiction of the revenue officer. Parties were co-owner in the property, which was partitioned, and Vanda jats were prepared accordingly. Mode of partition was made in line with the principle of consolidation and partition. Some land given to the applicant was not contiguous as he was in possession on the said land. Question of inferior land could not be raised, so it was in possession of the suit land. Question of inferior land could not be raised as it was on which partition was based. Partition of agricultural land was to be based on the classification and category of the land. Now the question is, partition of agricultural land. Who has the jurisdiction? The question has been dealt with in 2012 SCMR case 696. Jurisdiction of revenue court or civil court. Jurisdiction to grant such relief would be lay with the revenue court. Decree of civil court granting such relief would be nullity in the eye of law. It shows that if the property is land, then the jurisdiction lies exclusively with the revenue court, and if civil court takes the cognizance and exercises the jurisdiction in the partition of land, the decree shall be nullity in the eye of law. The decree granted by the civil court of partition of the property which is land and falls within the purview of Land Revenue Act 1967 and is within the jurisdiction of the revenue officer, then that decree shall not be followed. So far as the partition is concerned, another section 135A has been introduced. It carries sufficient weight. Partition in case of inheritance. It says, notwithstanding anything contained in section 134, immediately after the inheritance votation has been sanctioned, and without any application, the revenue officer shall serve notice on all joint landowners of the holding to submit within 30 days a scheme of private partition agreed to by all the joint landowners. If the scheme of private partition under subsection 1 is submitted, the revenue officer shall affirm the scheme in accordance with the provision of section 147. Number 3, notwithstanding anything contained in this act, a scheme for private partition between all the joint landowners may include site of a town or village. If the scheme under subsection 1 is not filed within the stipulated time, the revenue officer shall immediately commence proceeding for the partition of a joint holding. But there are certain restrictions and limitations imposed by this act on the partition of the property. Section 136 of the Land Revenue Act states, notwithstanding the provisions of section 135, place of worship and burial grounds held in common before partition shall continue to be so held after partition. And partition of any of the following particulars, namely any embankment, water course, well or tank, and any land on which the supply of water to any such work may depend. Any grazing ground and any land which is occupied at the site of a town or village may be refused. If, in the opinion of the revenue officer, the partition of such property is likely to cause inconvenience to the co-sharer or other persons directly or indirectly interested therein, or to diminish the utility thereof to those persons. In the said act, in section 36, for the word and figure section 135, the word and figure 134 shall be inserted. The general principle is that all the co-sharers are to be included in the partition proceedings. So the person not included in the proceedings shall not be affected by the partition proceedings. So the summoning of all interested persons by the revenue officer is necessary for making inquiry in partition application. Partition sanctioned without consulting a large number of co-sharers was set aside by the court. So it is necessary that all the co-sharers should be pleaded as party to the proceedings so that the rights of all of the co-owners should be determined, their vandas should be settled, they should be heard, and they should be given an opportunity to explain as to what part of the property is useful for them. So joint holding of parties, assuming the joint status, may be partitioned. The only remedy for a co-owner is to seek the partition of the property. Sometimes it happens that a person purchases the property from the joint holding and claims to be the owner of the specific place. He can't do it. Even if a person is purchasing the property from the joint holding and getting the possession of a specific portion, he shall not be considered as the exclusive owner in possession of that portion. Because, in spite of the fact that he got the possession of a specific portion, he shall not be considered as the owner. He shall be co-owner along with others. So it should be kept in mind that generally it happens that an owner enters into a contract of sale, gets the sale deed registered, and specifies the property with meets and bounds in the joint property. Any person who is selling the property from the joint property with meets and bounds with specification carries no weight because the status of jointness can only be finished by a co-owner after the partition of the property. When the property is partitioned and the vanda is given to him, then he shall become the exclusive owner. Otherwise, any device, any method, hmm, any trick, any representation shall not be sufficient to change the status and the nature of the property. A co-owner shall remain a co-owner in spite of getting the property specific.